Sounds great. I think he follows up Joseph Weiler's dichotomy on the social and formal legitimacy, and he defines in like a two-pronged definition. First of all, it's a formal legitimacy which corresponds to legality in the sense that democratic institutions and processes created the law on which they are based and comply with. But in its social character, the democratic deficit strives for a social legitimacy that connotes a broad, empirically determined social acceptance of the system. And if you take a historical perspective, you can observe that the biggest formal democratic deficit was not in 1992, it was not in 2009, it was not in 2003, it was actually at the very beginning. You see the way how international treaties were discussed there, and we take into account the fact that there were some major stakeholders like Jean Monnet and Robert Schuman that were in fact aware of the far-reaching consequences of the integration at that time. Actually, they were talking about the United States of Europe and so on. This clearly indicates that we don't have a problem of formal democratic deficit. It's something else, definitely. And it's always easy if you take violence, it's something that we speak about social characteristics of democratic lack of, I don't know, some normality. And I'll just briefly mention, because I'll go quickly through it. I see several other factors that completely reversed the story from the beginning until now. It's actually amelioration of ever-expanding competencies of the European Union, particularly those outside the scope of economic integration. Then substantial switch in the deliberation process, especially with giving more power to the European Parliament and with the qualified majority voting. And then definitely the structural and institutional remodeling of the European Union, especially with the direct elections of the European Parliament, and of course in the direction of more federated states. And I would say the fourth one is amalgamated in the focal point of the European integration, as Jean Monnet said, that this is a European citizen, as opposed to the concept of union of nation states, which was probably the idea of some member states. And if I can quote, and please excuse me my poor French, nous ne coalisons pas des États, nous unissons des hommes. It means that we should unite the people of the European Union. I think all these four factors I mentioned have one thing in common, that the power of the nation state slowly eroded through time, to the extent that the branded national identity felt threatened of these member states. And I will now probably discuss a little bit more in detail the German approach in last years. Yanni already mentioned the one from 2011, and definitely probably at the moment it was even more painstaking to read the German order on the request for injunction to halt ratification of the ESM treaty. German constitutional courts remain solidly on the so-called identity review. It means that until this eternity clause is not fully respected by at the European Union level, especially now the Gauweiler decision is not respected in terms of equal voting rights and so on, which is quite a bizarre thing to focus your identity on, to actually reduce it to only to the formal aspects of elections. We'll keep that in mind. We'll put that aside a little bit. So, the Constitutional Court is more and more criticized by the most prominent professors and academicians in Germany, for example, Thiem and other from Koblenz, criticizes that. Wait, I have to skip this a little bit. It criticizes with a warning that the deduction of precise limits for Euro-rescue operations from the principle of democracy in the German constitution eternity clause would have overstretched the options of hermeneutical interpretation and the role of constitutional judges. It is the right approach for the court to step back and let politicians take the helm. So, in a way, he said that the German Constitutional Court is not the first one and the primary source of actually dealing with such heavily exploding issues as creating a more interconnected monetary union on the European level. We would actually have certain impact as well on the fiscal policies of member states and of the European Union. I will now address as well at the moment there is definitely a constitutional dialogue of several constitutional courts. First of all, the Irish one already said that they would ask for a preliminary ruling as well. German court supported that, and now we wait for this final say on the validity of the ECM treaty, especially if it is in accordance with the Article 136 and whether the process of adopting it was in line with the Passerella clause. As already Janja mentioned, the answer to this rhetorical question whether the court would allow themselves to actually annul the process of ratification and adoption of the ECM treaty, I would say this is definitely a rhetorical question. I don't see a possibility to do it. Maybe they will issue some additional warnings like the German Constitutional Court always does, but I don't think this is something that is beyond my comprehension at the moment. Although, of course, we are now arguing with the result-oriented argumentation. We observe the result and then we try to legitimize the causes for this problem. This is not something that we should do in terms of methodology, but we shouldn't act as blind. And this is something I actually finished with. I will skip other things I would want to say because time is short. I see that certain European decision-making institutions, one of them of course being the European Central Bank, enjoy a unique level of insulation from direct democratic control. And this is where I touched your comment before. My first observation is that there is nothing especially European about this exception. First of all, it's precisely the same governmental function and monetary function that nation-states had before. If you take a look how national central banks were independent before transferring competences to the European Central Bank, we will see it was more or less the same, probably even less than at the moment. Although, for example, Moravcik argues that there is no obvious technocratic or normative justification for this. I strongly disagree, and I would suggest that ECB cannot function effectively, and probably this is a clash between accountability and independence and definitely efficiency. Why? Because we have to take a look at what is precisely the most important role of the European Central Bank, to be unpredictable in its defining the monetary stability. And by this, for example, if you observe possible solutions to the mitigation of democratic deficit. We can say that we could attach some consultancy before the deliberation process takes place in the ECB. But this is again contrary to the very idea of the central banking. So ex ante democratic process, so-called input legitimization, is actually impossible per se. I would agree with you here with Janja. But let's focus now to the ex post facto legitimization, for example, through reporting. This is actually done at the moment, and I agree with the probably very friendly approach of the European Central Bank, where they report more than necessary according to the statutes. But I strongly disagree. There is a possibility to actually intervene in the decision itself, and probably it's quite impossible for the independence reason to create a mechanism of individual or collective responsibility of the European Central Bank. And then we have to ask ourselves, what are the possible solutions to this? And probably the one is that we should have a lot of trust, and we should make a really huge effort when we nominate people to this position. Actually, the only mechanism we, as a democratic society, can do, through, of course, through our intermediaries. It seems that so far the results of the European Bank satisfy the needs and expectations of other political stakeholders and public as well, in guaranteeing monetary stability. An issue of democratic accountability will not fill the headlines. So far everything goes well. I believe that ECB will stay out of the main focus. But I believe that now the political and economic monetary stakes are so high so that every mistake that ECB does will actually reflect in the very problematic consequences, complete mistrust in the European Union institutions. So, and by this I will end my presentation. A result-oriented, so-called output legitimacy democracies eventually fail, even when the source of legitimacy, and this is now the case here, economic results are so far good. Welfare in European Union is so good, very good. Stability is here. So if this source of legitimacy diminishes to the extent it cannot conceal anymore the lack of democratic process or institutional shortcomings in the deliberating process, so this will be the point when the European Union actually loses all the credibility. Thank you very much. I was a bit, of course, I apologize for being like jumping from one side to the other, but I'm not very systematic. Don't apologize.
Okay, any questions? Maria?
Yes. Hello, thank you for your paper. I wanted just to raise some points in relation to the decisions of constitutional courts on these questions. So,
can you speak up a bit?
Yes. One thing that's very striking about the German decision on the ESM treaty is that whereas in Lisbon they said control of budgetary matters belongs to the nation state, the European Union has nothing got to do with this. In the ESM treaty on the 12th of September, they say so long as the national parliament has oversight of what's happening, this is sufficient in order to respect the guarantee via Article 79.3, the eternity clause for the protection of German democracy. So just to see what you thought about that. Also, if you had looked already at the decision of the Latvian Constitutional Court on this question, there the court is split 10-9, so there's a very strong dissent. I haven't read it, although I have access to it, but it's something that probably is worth looking at. And then I have had the chance, I'm Irish, so I actually know the lawyers who are taking the Pringle case before the ECJ, and I have seen their submissions, and all of their arguments are to do with the rule of law. So actually their first concern is that we are moving too far away from rule of law towards rule of men, and this is sort of something that you are conscious of to the extent to which you say now we need to replace law almost with trust. So as a lawyer, I can't kind of accept that very easily, and I'd like to know what you think about the implications for the rule of law, whether you see this as a negative consequence of what you're proposing.
Yeah, first of all, I would quickly answer the last question. I haven't read it either, so I can't comment it. But I will take a look as well. Probably it's definitely a good break in the whole story. As it concerns the German Constitutional Court, I would say that they made a first step back, and probably this is something that they had to do. They were in a way forced to do it because of the situation. Economic realities were so strong that they couldn't stay so strong from the identity review anymore. I would say that what the German Constitutional Court always does is that it always sticks to the national premise. Article 79 through paragraph 3, Article 1, and so on. In a way, they would have to, at one point, accept, sooner or later, in my opinion, that the issues are so interconnected in the European Union that just always trying to find the legitimation in the Grundgesetz is probably a position that could not be defended in future anymore. Probably so far they could hide themselves behind the primacy of the German constitution. But it was already in Gauweiler, the decision was pretty much bizarre to observe bashing of the process, how things are done in the European Union level. But at the same time, when we see the tenor of the decision, they always do the contrary. So they always have this argument only that they are open to the, I don't know how to say it in German, they are open towards the European Union. And this is the only argument that they put forward actually that supports the tenor. And then you have like 300 paragraphs of bashing. There's something really inherent to the German identity that should not be avoided. And I believe that from the economic, for the economic reasons, they were unable to do that anymore with the ratification of the ECM treaty. So, but this is my political observation on it. It's not a legal analysis. So finally, the third one was on Irish. On the rule of law, yeah, of course. If you read the preliminary ruling, actually the reference for preliminary ruling, it is very well written. Those who proposed it actually were very careful in structuring the questions. They would like to, they asked the court to pay particular attention to the general principles of the EU law. I'm quite sure that the court will say that there was no breach of limits of competence.
I'm sure they will too, but I also think they're wrong.
Yeah,
they won't be right about that.
Yeah. So, but they are now in a moral dilemma what to write in the see how to actually argument it. It's hard. I gave one solution. They will have certain restraints for future actions. So, okay, now we will allow it, but for the future situation, we would like to do something else. I'm not a good economist, but I have a huge problem actually with this national understanding, like the national position that there shouldn't be a transfer of competences for the European stability mechanism. Do we all see that 27 insular system would have a better efficiency? So I'm actually raising the argument of the principle of subsidiarity. For me, it's like a prima facie, something that I prima facie observed that it could be done only in a centralized way. For two reasons. First is subsidiarity, actually the element of efficiency, and the second one is solidarity. Something that probably people don't want to hear, especially people in the countries that are more developed. This is something that we have an experience in ex-Yugoslavia. Everybody was exploiting each other at the end.
Yes. All right. Any other question? Then I'd like to add something. When you were discussing the status of the ECB, you were stressing the importance of its expertise, independence, impartiality. You didn't mention the integrity of those appointed, but I'm sure you had those that in mind too. And you mentioned the process of nomination of these people to the ECB, and then you were in a sense alluding to the supremacy of the ECB in the monetary matters, right? To what extent is then ECB different from or could we draw an analogy between the old debate about the supremacy of the constitutional review and the supremacy of the constitutional courts, although that was in the field of human rights protection, to the status and role of the ECB in these monetary matters? Isn't that very similar? Because you also cannot vote, even in Slovenia that's impossible, that you make a vote on whether you like or dislike the decision of the Constitutional Court. And so, the same way you are arguing, we cannot allow a direct or this input democracy, popular vote, parliamentary debate, or parliamentary decision eventually on the decisions of the ECB. Isn't there? Can you draw some parallels? Would that be possible between both institutions?
I see a slight difference between the ECB and the old debate on the supremacy, principle of supremacy in the field of human rights. First of all, ECB supremacy is enacted in the treaties itself. So this is something that was not for the human rights, and probably will never be, because I believe that a dialogue between the constitutional courts is definitely something worthwhile, and probably national courts will not allow something to actually pass it completely to the European Union courts. Probably there's a bigger debate between the role of the European Central Bank and in regard to those central banks that are not part of the countries that are not part of the Eurozone. So, I'm not familiar with the processes there, because this is not my topic. How the other central bankers from governors of central banks, for example, Bank of England and so on, how they can actually influence or have at least a consultation or give an opinion on certain issues, whether they are informed of the certain decision. Because in a way there is a conflict, but they have an interest to protect the stability of British pound. But I'm not an expert here. So.
Okay, thanks. Any other question? Okay, so thank you very much, Sasha. And now we give the floor to the last speaker on the subject of the European Union, and that's Katarina. Katarina, please. Go ahead.
I might get warmer now. Let me first express my regret for not being here earlier and listening to all of you and your presentations. My background lies in European and international law, not legal theory, so I think this will be reflected in my presentation today. In this, to some extent, modest presentation, I will touch upon the restrictive measures of the European Union as a tools of EU foreign policy. But before I start, let me give you a short outline of this presentation. I will touch upon different notions: crisis, restrictive measures, trust will be mentioned, but in different meaning. I will then focus on the limits the European Union has when using restrictive measures. The limits in terms of general principles that should be used or governed, that should govern these restrictive measures. Now, why is this important? Because I find more and more that international organizations, and I don't want to go into the question of the legal nature of the European Union, let's put it here as an international organization, with the will of member states or more powerful member states or some member states, take measures that deeply affect human rights without sometimes thinking of all the consequences that of this decision that might brought to individuals or have only political, economical and other reasons in their mind. So to begin with, the crisis. It is widely acknowledged that periods of crisis have a negative impact on the respect of fundamental rights. Now, the current economic crisis in the EU shows no different. It seemingly affects fundamental rights in various ways: social rights, the level of health protection, and so on. The newest editorial of the European Law Review, a very prestigious journal, puts it nicely by saying, attention has focused in recent months on the resolution of the Eurozone crisis. And we've seen the panel is devoted to that. But it continues. Political problems obviously persist beyond that narrative. And for the purpose of this presentation, I want to go beyond that narrative, beyond the current economic crisis, perhaps in the period where the economic crisis was not that imminent, at least not experts like I am. I want to go to another crisis, or the events that were brought by the September 11th, because there the restrictive measures comes into play perhaps very vividly. The so-called war on terror, of course the words that were not best suited, began by flying airplanes full of innocent people in the symbols of richness, of westernness, and so on. I don't need to explain no further description or explanation because we were all aware of what was going on. And that brought a significant degradation of fundamental rights. And the quite frequent use of restrictive measures as a tool of EU policy was a consequence of this event. And I depict it as an example of this degradation of human rights. Now let me turn to restrictive measures, more colloquially sanctions, though neither EU Charter, United Nations Charter or EU treaties don't mention sanctions. They mention restrictive measures. They talk about measures not involving the use of force. These restrictive measures have its history in international relations. Actually, the development of this tool is quite interesting, focusing on multilateral sanctions used by international organizations. I can say that the UN adopted first sanctions against South Rhodesia back in 1965. We could trace the restrictive measures even further in the past, because the League of Nations, the predecessor of the UN, actually was able to its member states to adopt once in 1931 measures against Italy because of her aggression on Abyssinia. So that was the beginning of multilateral sanctions used by international organizations. Now the post-September 11th era brought a transformation from this completely focused on state sanctions that received a huge amount of critique because they affected innocent people, because they